During a pretrial question and answer session known as a deposition in a medical malpractice case, is there ever an opportunity where it's okay for you to guess at the answer? Would you like to know the answer? Come join me for a walk along the water as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. The short answer is no, it is never okay to guess. Now, why do I say that? You may think that because you don't exactly remember the answer, it's okay to go ahead and guess. You might think that it's okay to go ahead and give a range of things that you think are accurate without really knowing the exact answer. So let me give you an example. Let's say the defense attorney asks you a simple question. Hey, Mr. Jones, what is today's date? Now, either you know the date or you don't know the date. If you know the date, you're going to answer the question. If you don't know the date, then you simply turn around and say, I don't recall, I don't know. Now, why is that? So let's say instead of answering that way, you turn around and say, you know what? I'm not sure exactly. It might be the 13th, it might be the 16th. These days all run together. I'm not sure. Maybe it's the 16th, maybe it's the 15th. And now you ramble on and on about what you think the date might be. Is that an appropriate answer? In my opinion, absolutely not. Why? Because he didn't ask you what you thought. He asked you what was the date. If you know the answer, you tell him. If you don't know the answer, tell him. Now, if you don't know the answer, in all likelihood, the attorney is going to ask a follow-up question. Mr. Jones, are you having a problem with your memory? Are you taking any medication that impairs your memory? Have you noticed that you've had a memory problem over the past year or two since this incident happened? And now you can begin to respond to those questions when he follows up. But to answer the question, do you know the date? It's either yes or no. Okay, what is the date? Oh, today's the 13th. Excellent. Now he'll move on to the next question. Now, there are some instances where you may have no choice but to guess. Now, why do I say that? Because in some instances, the attorney may turn around and say, hey, can you estimate for me the period of time that you were on the hospital floor before you were transferred to the MRI? Now, if you remember, terrific. If you don't know the answer, tell him, I don't know. Okay, if you don't know the answer, he may turn around and follow up and say, hey, Mr. Jones, can you give me an approximate time frame that you recall being on that floor before you were transferred to the MRI? Well, I think it was more than an hour. Maybe it was less than 2 hours, somewhere in between then. In that scenario, he is now asking you to estimate, not so much guess, but to try and estimate, or to give a range, a parameter of time that you were now on the floor before you were transferred to MRI. Now, why is that important? If he's now trying to understand the timing, it means that the timing is important for his defense. It could also mean that the timing is important for your particular case. Because oftentimes in these hospital-based cases, we argue that your condition was not timely recognized, diagnosed, and treated. And now timing can be very significant. Okay, when did you notice that the doctor was there? When do you recall that the nurse was then next there? When? And if you don't recall the exact time, you've got to tell the attorney, I'm sorry, I don't recall. It's been 2 years since this incident happened. I simply don't remember. Okay, I understand you may not remember exactly, but can you give me an approximate time that you went from here to here, from point A to point B? And now you try and give him an approximate time. Don't fall into the trap of thinking, okay, I'm now going to guess off the top of my head that maybe this is what it is, maybe it's not. The reality is that when you guess, you might be right, but then again, you might be wrong. Our memory changes based upon our perception, based upon the length of time from which the incident occurred, and now our mind fills in gaps as to what we think actually occurred based upon our own memory, as well as people telling you what happened. And if now you're basing those answers from what someone else told you, now that's not an accurate representation. Why? Because the attorney is trying to find out what you remember. If you don't remember something, it's perfectly okay. We, as the attorneys, have your medical records. The defense lawyer has copies of your medical records. Based upon what's contained in the hospital chart, we will know the approximate timing, or we should know the timing of events, unless, of course, they did not document certain events that are critical to your particular case. In that instance, now every single person who's going to be questioned in these pretrial depositions is going to be asked many questions about their recollection, about their memory of the timing of when certain things occurred. I just had that in a case I did a deposition on where I was questioning an orthopedic doctor. Now I'm asking him specific questions about when he's notified in the middle of the night, what actions he took following that, when he next spoke to the other doctor, what conversations he had with the nurse at that point, and it just goes on and on. Why? Because many times these conversations are critical and essential to understanding the sequence of events that occurred, especially in a hospital-based scenario. So why do I share this quick information with you? I share it with you because many injured patients are so worried about not knowing the answer to a particular question during this pretrial deposition process. And that's totally understandable. But what you have to recognize and you have to realize is that nobody is expected to know every single detail of every single event to every single question being asked of you during the deposition. And I would suggest that if you did know every single detail and every single minute-by-minute event, that something is not right. That either you have it recorded, either in a document or in a video or an audio or somewhere along the way, and now you remember every single detail and every single event. It is highly, highly unusual for that to ever occur. And it is totally understandable when a witness turns around and says, "I'm sorry, I just don't remember." You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.